Welcome to this tutorial on Introduction to Intellectual Property Rights. Intellectual property refers to the creation of the mind, inventions, literary and artistic works, and symbols, names, and images used in commerce can be your intellectual property. Intellectual property rights are like any other property rights. They allow creators or owners of patents, trademarks, industrial designs, geographical designs, or copyrighted works to benefit from their own work or investment in a creation. These rights are outlined in the Article 27 of the Universal Declaration of Human Rights, which provides for the right to benefit from the protection of moral and material interests resulting from the authorship of scientific, literary, or artistic productions. Intellectual property rights reward creativity and human endeavor. There are two categories of intellectual property rights. First one is industrial property, which includes patents for inventions, trademarks, industrial designs, and geographical indications. And the second one is copyright, which covers literary works such as novels, poems, and plays, films, music, artistic works, for example, drawing, painting, sculpture, etc., and architectural design. Now going on to patent. Patent provides patent owners with protection. That is, an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. Protection is granted for a limited period, generally 20 years. Who all are entitled to apply for patents? First category is any person claiming to be the true and first inventor of the invention. Second, any person being the assignee of the person claiming to be the true and first inventor in respect of the right to make such an application. And the third, the legal representative of any deceased person who immediately before his death was entitled to make such an application. Now we'll see what rights do patent owners have. A patent owner has the right to decide who may use the patented invention for the period during which it is protected. Patent owners may give permission to other parties to use their invention on mutually agreed terms. Owners may also sell their invention rights to someone else who then becomes the new owner of the patent. In order to get a patent, the first thing that you have to do is to file a patent application with the IPR office. The application must contain title of the invention and an indication of its technical field. You should also include the background and a description of the invention. Now I'll proceed on to what kind of inventions get protection. The invention to get a patent must be of practical use and it must show an element of novelty outside prior art. That is, some new characteristic that is not part of the body of existing knowledge in its particular technical field. The invention must show an inventive step that could not be deduced by a person with average knowledge of the technical field. And finally, its subject must be accepted as patentable under law. Now, to make you understand the term patentable, I will ask you a question. Can you think of any invention which is of practical use, novel, and still cannot get a patent? You can pause the video Think for some time and then write the answer in your notebook. Hope you have answered the question. So now I'll come on to the answer to what is patentable. Scientific theories, mathematical methods, plants or animal varieties, discoveries of natural substances, commercial methods or methods of medical treatment as opposed to medical products are not patentable in many other countries for obvious reasons. Hope you have understood what I mean by patentable. Now moving on to the next category, that is trademark. A trademark is a distinctive sign, maybe 2D or 3D, that identifies certain goods or services produced or provided by an individual or a company. Trademark protection ensures that the owners of marks have the exclusive right to use them to identify goods or services, or to authorize others to use them in return for payment. The period of protection varies, but a trademark can be renewed indefinitely upon payment of fees. Trademark protection is legally enforced by courts that have the authority to stop trademark infringement. The process of trademark registration is as follows. An application for registration of a trademark must be filed with the appropriate national or regional trademark office. The application must contain a clear reproduction of the sign filed for registration, including any colors, forms or three-dimensional features. It may also contain a list of the goods or services to which the sign would apply. The sign must fulfill certain conditions in order to be protected as a trademark or other types of mark. The first thing is that it must be distinctive so that consumers can distinguish it from trademarks identifying other products, as well as identify a particular product with it. Number 2, it must neither mislead nor deceive customers nor violate public order or morality. The rights applied for cannot be the same as or similar to rights already granted to another trademark owner. This be determined through search and examination by national offices or by the opposition of third parties who claim to have similar or identical rights. Now we'll move on to the next section, that is copyright laws. These copyright laws grant authors, artists, etc. protection for their literary and artistic creation, generally referred to as works. It benefits people like performers such as actors and musicians in their performances, producers of phonographs in their sound recordings, broadcasting organizations in their radio and television programs. Works covered by copyright include, but not are limited to, novels, poems, plays, reference works, newspapers, advertisements, photographs, sculpture, architectural buildings, maps and technical drawings. What rights do copyright owners have? The exclusive right to use or authorize others to use the work on agreed terms. The right holders of a work can authorize or prohibit its reproduction in all forms, including print form and some recordings, its public performance and communication to the public, its broadcasting, its translation into other languages, its adaptations. They also include moral rights, meaning the right to claim authorship of a work and the right to oppose changes to the work that could harm the creator's reputation. I hope you have got a brief idea about various intellectual property rights. Now go ahead and see whether you can complete the quiz on IPR that is available in your course. Thank you.